Okay, thank you. Let's go ahead and get started. Senator Ellis, you can stay out there and finish your sandwich for a moment. This is Welcome to Minerals Committee, Wednesday, February 28th, noon recess. We are going to go straight to the bills because we have an hour. And then before we close, we need to talk about an interim topic date and time. And the sponsor of 141 and 145 said they were sending people to present. Who has 141, State Land Oil and Gas Lease Operator? Representative Conrad, thank you for joining us. Go ahead,
Mr. Chairman, members of the committee, it's great to see you again. I'm presenting to House Bill 141, which is entitled State Land Oil Gas Leases and Operator Requirement. Chairman and members of the committee, if I could, I'd like to begin by walking through it, a little more importantly, directing you to page 2, which is really the meat of the bill in its intent. If I may, with your indulgence, read through this. What this does is before issuing a lease of any state lands or state school lands for oil and gas productions, that's what's important, for any oil and gas production under this article, the director, subject to the criteria listed in specifically under 36.6.101 and item H defines that criteria, established by the board, shall review the highest bid offered, in this case to that land, by the applicant to determine if the applicant is truly qualified and is an oil and gas lease applicant in accordance with the rules of the board. Now, if the highest bidder is not a qualified bidder, then the board shall consider the second highest bidder to determine whether the bidder is qualified applicant, upon which the board may issue the lease if the applicant agrees to lease the lands for the highest amount bid before the disqualified applicants can. I think I'll stop there and share with you the motivation behind this bill is to ensure that folks who are bidding on lands, specifically oil and gas leases, are truly doing so for that purpose. That they're not tying up these lands to the highest amount, more importantly for, say, a conservation easement, et cetera, so forth. So we're trying to ensure that people who are truly going after these lands for the oil and gas are truly oil and gas people. That there's no nefarious activity with regards to locking up a specific area or specific area of land for that. And within that, on the latter pages, or more importantly, in the latter sections there, you'll see a beginning in line 15 on page 2, any applicant whose bid is rejected under this subsection because the applicant is not a qualified gas or lease applicant shall be subject to a civil penalty. This ensures that there are some checks and balances, but more importantly, some repercussions for those people who are trying to buy these lands for other purposes and or not for oil and gas.
Okay. Representative Conrad, you talk about civil penalty. Can you line that out anywhere as far as what you're thinking there or what the sponsor's thinking?
Yes, thank you. On line 18, it continues, a civil penalty, Mr. Chairman, in the amount of the applicant's highest bid. And then we also allow the opportunity for the Attorney General, his option or hers, that may bring an action in the court of the competent jurisdiction to recover that penalty specified in the subsection. So specifically, Mr. Chairman, to your question, it would be in the amount of the original highest bid.
Okay, keep going. Anything else?
No, sir, I believe that's really in the essence of time and your attention. I think I'll stop there.
Committee questions on House Bill 141, State Land Oil and Gas Lease Operators Retirement? Go ahead.
Thanks, Mr. Chairman. I guess I want to know if this is actually happening or a concern. I'm worried about adding modifications to the obligation for highest and best use, which is effectively what we've directed, right? Make as much money off of this land on behalf of the schools as you can. That would already, in theory, be the algorithm that they would use. So I don't know how anyone could come along falsely and say, "Ooh, we want the oil lease," and then that due diligence wouldn't take place. So maybe I'm missing something, but I just wouldn't see it being leased to a false operator for oil purposes, oil and gas purposes.
Representative Conrad, do we have situations like that out there?
It's my understanding from the author specifically up in the Sheridan area, there is a concern that this may happen. And I would also refer, Mr. Chairman and Senator Rothfuss, I would ask our friends from the Petroleum Association of Wyoming to give some specific examples towards that. So this is a proactive preventative measure bill that we see an influx of foreign adversaries, or more importantly, foreign entities coming in that are not allowing, or more importantly, buying land.
Representative Conrad, would this be similar to what we're seeing in the Intermountain West with Idaho and other ag lands all of a sudden being just locked up?
Mr. Chairman, that's a great example.
Senator Trullo,
Oh, go ahead.
Senator Cooper.
Thank you, Mr. Chairman. Representative Conrad, excuse me, how do we determine who is a qualified bidder?
Representative Conrad?
Thanks, Mr. Chairman. Senator Cooper, right now, that would fall into director, not using names, but the director to ensure that that land is truly, or more importantly, that lease is truly for that purpose. So that's right now the checks and balances that I have, and I believe that gentleman representing that office is here today to share with you the insights in terms of that determination.
Okay, thank you. Any further questions? Go ahead.
Sorry to, push back on that earlier answer, but the idea of buying lands, this doesn't deal with that, right? This deals with leasing of state lands, whether it's state trust lands, school lands, or state lands, leasing, and it's even specifically for oil and gas production. So the first part, establishing criteria for what that canon should look like, kind of makes sense, but the idea that they wouldn't be seeking highest and best use in this circumstance, I guess I'm missing that. So I'll ask them, but it doesn't have anything to do with purchasing and sale of mineral assets. You're not infringing on private property rights in this in any way, right? It's just access to oil and gas operations on state lands. Is that accurate?
Representative Conrad?
Chairman Dockstader, Senator Rothfuss, you're accurate.
Okay.
you.
And one final question, Mr. Chairman.
Go ahead.
On line 15, any applicant whose bid is rejected under this subsection shall be subject to a civil penalty in the amount of the applicant's highest bid. How would that play out? Because I mean, there's not like a specific bid of I bid $500, right? I mean, it's a rather complicated agreement that bid represents, and it's going to be based on production so there isn't a bid there that would be that civil fine that would potentially be available. I guess I don't understand how that would be calculated or who would calculate it.
Representative Conrad?
Chairman Dockstader, thank you. Senator Rothfuss, it's a good question. And those areas would obviously have to be determined. But what, in this case, what the bill represents is just if the applicant's bid is $500 and we find that applicant is not a qualified bidder, the penalty in this case, we would seek the $500 back. And that will be a process that would happen under the director's
Senator,
review.
you good?
Just one more. And so the final question is all the work we did over the last, well, it wasn't last year, but it was the prior 2 years, on drilling permits and working with OGCC on a process that made sure that it was more challenging than previously to lock up leases and that those would have to either be used or effectively released. You don't feel that that's a sufficient process to protect here in case somebody actually did? Because we have a tremendous amount of leases that are leased already by bona fide oil producers that unquestionably are hoping to produce, and yet they still don't produce. And so we spent a couple of years working on that problem, and I think we came up with a relatively good approach to that. What's the shortcoming of that process that needs to be remedied?
Representative?
Chairman, thank you. Senator Rothfuss, right now, from my perspective, and more importantly, the author of the bill, we don't believe there's the due diligence or checks and balance that would prevent this from happening in the future with the current legislation or the current statutes we have. There could, in fact, there is an opening that we're trying to tighten up, if not close.
Okay. All right, that's it. Further questions from the committee? No? Okay. Thank you, Representative. Just stay right there and let's bring some people forward. Anybody else would like to testify on this bill? Maybe Representative Conrad, you move down one, clear up a couple chairs. Your ground support.
Move down.
Okay. Go ahead and jump right into, we've got another 2 o'clock or 1 o'clock return, so go ahead.
Mr. Chairman, members of the committee, I'm Jennifer Scoggin. I'm the Director for the Office of State Lands and Investments. I have Jason Crowder here with me. He is the Deputy Director for the agency.
Thank you.
We have a few concerns about this bill. And largely, it stems from the prevalence of the problem that the bill is stated to address. In my tenure here with the State Lands, which has been about 6 years, we've only had one instance where an NGO, if you will, was able to participate in the oil and gas lease auction successfully and be the successful bidder. And when we received the results of that lease auction, the name of the entity was readily identifiable as an NGO, and we knew that they were not likely going to produce the lease. And so the board has a rule in its toolbox that essentially allows the board to not issue the lease in the event that they find it not to be in the interest of the trust beneficiaries. And so as the director, I recommended to the board that it not issue the lease because we did not believe that the lease would be in fact produced. And so the board followed that recommendation. It did not issue the lease. Now in that particular situation, the NGO was the only bidder on that particular parcel. And so there wasn't a second bidder. It went back into the pile, if you will, to surface for another oil and gas lease auction. However, we are aware of a couple of other instances in which this same NGO participated in some oil and gas lease auctions, but they were not the successful bidder in those cases. And again, our procedure, had they have been the successful bidder, would have been to identify them as, you're likely not going to produce the lease, probably go to the second highest bidder and take the second highest bid. That would have been our procedure had they been successful. Now, there was testimony at on the House Minerals side that this is becoming a huge problem, if you will, and that it's costing industry, it significantly impacts leasing costs for the industry. And like I said, this has not been our experience, but wanting to get to the bottom of it, we also had not had industry representatives knocking on our doors saying this is becoming a huge problem, State Lands, we need you to do something here. So nevertheless, our online oil and gas lease auction vendor, we went to them and asked for any data that they could supply to us so that we could see if in fact this is becoming a more prevalent problem. And they had data from as far back as 2016. And we reviewed over 12,775 individual bids that have taken place in oil and gas lease auctions since 2016. And we were only able to identify 4 parcels on which an NGO had bid. And in one instance, they were the successful bidder. That's the one that I just explained to you previously. And in the other 3 instances, one, the NGO stopped bidding at $10. The parcel sold to another for $11. In 2023, the NGO stopped bidding at $22. The other bidder bid to $28. And then in the final one, they stopped bidding at $18 and the parcel sold for $19. But with that said, we do acknowledge that the results that we were able to get from our vendor aren't always going to identify people who do not intend to utilize the lease, because there are folks that they are individually registering, or there may be LLCs registering that we're not familiar with, or perhaps they're not obvious on their face that we know them to be an NGO that would not want to develop the lease. So anyway, we don't believe this to be a prevalent problem, just with our experience. With respect to costs to the industry, we understand their concern that, that the NGOs may participate in these and bid them up and that sort of thing. But we believe that presumably industry has done its homework and it has decided what it's willing to bid for the lease and what they believe the market value of that lease to be, and they would quit bidding when they reach that. So if an NGO were the successful bidder and we disqualified them pursuant to our existing process, we would expect that the second highest bid would be taken, and that the bidders are consciously bidding what they're prepared to pay for the lease. So we look at it as similar to a sealed bid situation where, sometimes in our, like with ag leasing and that sort of thing, we do a sealed bid where we say, give us your highest and best offer, and it's sealed. To us, this is sort of a similar thing. If you're participating in the auction and you're willing to bid a certain amount, and then you drop off and you become the successful bidder because there's been a disqualified bidder, you're still willing to pay for that. The other piece of it is our oil and gas leasing process. It's a blind process, so you may not necessarily know who you're bidding against. It could be your competition, and you weigh that as you're participating in the process. The other piece that I would say about that is we need to remember who we're doing this for. And we have a fiduciary duty to the trust beneficiaries to drive and generate revenue off of activities on state trust lands. And so, in fact, we're looking at ways all the time to drive revenue. And one of the things we are going to be doing in March, we are going to sort of pilot a couple of our oil and gas lease parcels into a sealed bid situation to hopefully pull out a true value of the parcel rather than just allow somebody to win it for $1 an acre. So we're trying these things all the time. Getting to the bill itself, and I know that we're on a time crunch, and so I'll just give you our concerns there. With respect to House Bill 141 on page 3, section 2, where it says the board must define a qualified bidder or qualified oil and gas applicant, our concern is that there may not be a specific way to capture every potential entity that could legitimately participate in this process, because we're going to have a definition that encompasses, lessees that only hold the lease, but don't produce. They hand out operating rights or lease rights and only retain royalty interests. Perhaps they're speculating that somebody else is going to come in and buy the lease from them. Or perhaps they're securing larger acreage plays to package and sell to other operators. Or maybe they're securing a lease that's already in an existing oil and gas unit or a CA with another operator. So we're concerned about this expansive definition and capturing all parties that legitimately do have, some sort of end game, if you will, to get a lease developed. We are concerned about the civil penalty. We feel like it's kind of a double whammy, if you will. We think, if the goal is to remedy a situation and where some of these unqualified bidders are successful applicants and they feel like they're driving that price up in an illegitimate way, we feel like the penalty to, once you disqualify the ineligible bidder and then you have the second highest bidder pay, whatever the illegitimate bidder came in at, that sort of resets the playing field, if you will, and takes away that concern about just driving the price up. With the civil penalty, it seems a little punitive. It's, if the purpose is to offset any of our agency costs or that sort of thing with respect to all the additional vetting, we're not sure that gets this done. It's my understanding that civil penalties, that they, unless it's otherwise provided by law, that they go to the public school fund of the respective county for local support, not the trust beneficiaries collectively. When we do oil and gas leasing, those revenues, if you will, come in and are given out or in a collective manner for all the trust beneficiaries in the way that they're distributed. The other thing here is we think that there may be other ways to address this concern. Rather than this particular bill addresses unqualified bidders on the back end. Maybe it would be easier to explore vetting these on the front end so that when the qualified bidders are participating, presumably those that aren't going to be in the mix legitimately have been disqualified early on, so then we don't have these other things going on. And certainly we believe we could do this through rule, and we believe that our existing rule actually works. And but nevertheless, we would be willing to work with industry to craft something that works for everybody. And if we go through the rulemaking, we would have the benefit of public comment in the mix as well. So, and despite all of this, as I mentioned, I think there's really no foolproof way to make sure that somebody who doesn't have the desire to develop a lease isn't participating, because as I mentioned, they can register individually, they could register as an LLC, they may not be readily identifiable as an NGO or somebody that we could even identify. I would like to, Mr. Chairman, I'd like to turn it over to Deputy Crowder at this point. We do have a proposed amendment that we would hope that the committee would consider.
Deputy, you have an amendment? Do you want to pass it out to the committee?
Mr. Chairman, yes, it's already been passed out to you, I believe.
It's in my folder, Ryan. Got it, okay. Thank you, go ahead.
And Mr. Chairman, as the director mentioned, what the amendment does is largely pull in what's in rule. What's in rule isn't guided by what's in current statute, so we would kind of be doing the process a little bit backwards. But I'd like just to read the rule to you that the director has used to deny an NGO lease in the past. And it's Section 3 within the Board of Land Commissioners Rules and Regulations in Chapter 18. It states the board may refuse to issue an oil and gas lease or approve an assignment of an interest in an existing oil and gas lease if issuing the lease or approving the assignment will diminish the interest of the beneficiaries. And so what we've done in the proposed amendment for you is to pull that section of rule into statute. And so instead of trying to define qualified bidder or qualified oil and gas, applicant, as the director mentioned, with all of the problems that come along with that and the unintended consequences, we pull in what's in the board's rules already to require and give everybody notice through statute that we want these oil and gas leases to go to individuals who have an oil and gas nexus. They may not be the operator, but they may be the person who's pulling leases together, who's pulling plays together and selling it for somebody else who can develop it. And that's what this rule does for us. And so what we've done is we've pulled that into the statute, and hopefully that will alleviate the concerns that a non-qualified bidder or somebody who we believe is not in the best interest of the beneficiaries would be vetted out of the process as we go through who wins the oil and gas lease auction. The second thing that the amendment does, as the director mentioned, is it removes the civil penalty. And as she mentioned, that becomes problematic for who that penalty actually benefits, how it would be assessed, if you will, and does it actually stop the practice of NGOs bidding on oil and gas leases when that's not the intent of the lease? And so our attempt here is to just stop them from participating. What it does is it drops the highest bid down to when they entered the auction. And it allows a legit oil and gas operator or somebody who is in the best interest of the beneficiaries from an oil and gas standpoint to just bid what they intended to pay before they stopped bidding or before they were outbid by the NGO. And that creates a situation where the NGO is no longer causing chaos in an oil and gas leasing process. So it's as if they were never there. And if they were never there, there's no need to charge a penalty. And so that's what we offer in this amendment, is to make that clean. It is what we currently would practice, as the director mentioned, if we were to ever to get into this situation, which we haven't yet. And then the final thing the amendment does, Mr. Chairman, is just remove the requirement to define qualified bidder and define qualified oil and gas lease applicant, because we don't need to do that. We're simply looking at who is in the best interest of the beneficiaries. And Mr. Chairman, that's a quick review, and I'm happy to answer any
Should
questions.
they ask questions for either the director or the deputy director? Questions, go ahead.
Thank you, Mr. Chairman. I like most of this approach. The concern I have, it's the same concern with the bill regarding setting the price. One of the concerns, setting the price at the price when the, we'll say, non-bona fide bidder enters the process. Because everything from that moment is in question, but it doesn't mean that the bid prior to that entity entering the bidding was the correct bid. Imagine that you had 4 bidders and one of them was sketchy, and they came in at $3. Well, congratulations, you just got a $2 lease based on how this is structured, based on how the proposed bill is structured. And that is obviously not the intent. The intent is to get towards a real price where the auction was not in any way manipulated, and all of the true competitors were engaged in it. So I think the first part is good, but I also think that you probably already have the authority to remedy even that situation, would be my guess. And that if there were a situation where you saw that somebody came in, they ended up mucking up the bidding process, what would you do in that circumstance? So now say there's 4 bidders and one of them just starts playing with the numbers and maybe some people drop out. How would that be handled now?
Either one of you?
Mr. Chairman, Senator Rothfuss, exactly as the example the director mentioned, when we recognized that there was an applicant who had no intention to develop or move the lease in an oil and gas manner, that we recommended to the board that they refuse issuance of that lease. If there was another bidder in that situation, and specifically to your example, we would go to that next highest bidder who had an intent to use the lease for an oil and gas purpose and allow them to pay what that amount was. And that's what we're expecting to do here, regardless of how far down that bidding tree it goes.
But again, a strange circumstance where it's going back and forth a little bit, and then that individual, it's 22, 23, 24 going back and forth among reasonable bidders, and, sketchy bidder comes in and says $100, and then all bidding stops at that point. So under that circumstance, you go back to the 23 and you say you can have it for 23 when the bidding was still ongoing. I'm not sure that that is a successful remedy, because it never had the opportunity to play out, and it was an influenced bid. Again, the current bill doesn't address that. I don't know that this remedy addresses that, but it almost, and I'm sure you'd have the authority to just go rerun the bidding, would be my suspicion of what might be an appropriate remedy for that circumstance. You'd have that authority, correct?
Go ahead.
Mr. Chairman, Senator Rothfuss, yes, we would have the ability to go back and redo that. And if I could just add one more thing, when we were aware of a situation with an NGO, dabbling, if you will, in the bid process, we did take them aside and slap their hands a little bit and said, this is not the way, this is not the tool that we would prefer to be utilized to address conservation or surface damage concerns. And we are looking at trying to do some conservation leasing and that sort of thing, so that at some point we do have the proper tools to address what those concerns might be. It's just taken us a little time to get there.
All right, committee, further questions? Go ahead.
Thank you, Mr. Chairman. In looking at the language, I understand where this is probably more precise legally, but what I'm struggling with is the bill, I think, is written, in my view, as it trying to deter people from bidding altogether. And so there's some appeal of just kind of the plain language of the bill as it is. So I'm struggling with that a little bit. On the penalty, I'm struggling with that too. Again, I think that the purpose and the bringers of this bill are looking to prevent anyone from, entering these bids without a true intention of actually developing the minerals. But if you could just maybe cover again, as an alternative to having to bring some kind of prosecution, would just Office of State Lands keeping the revenue that they paid for that lease? I'm just wondering if you've collected that money and it's enough to say, okay, we're going to keep your money and we don't have to bring some separate action. But I don't know how that works in your process. So those are my two concerns or things we could chat about.
Either one of you, go ahead.
Mr. Chairman, Senator Ellis, it is our intent too to deter these types of bids coming in. They cause havoc, they cause chaos, and we don't want them to see it as a beneficial thing for them to do to influence surface activities. And that's why we offered the amendment, that they do not get to do anything other than cause a little administrative work for us on the front end, which we already do. So the deterrent really is that they've come in, they've not increased the bid, they've not required an oil and gas operator to pay any more than they already would have paid. There's just no impact they've made to the process. And so we thought that that was a good enough deterrent. And through our experience, as the director mentioned, that is what they want to do. They want to make it uneconomical, or at least make them pay attention as far as the bid amount that an oil and gas operator would pay. And then if they won, they would be able to influence how the surface was used and possibly not used at all. And so we feel through those conversations, this is an appropriate deterrence. As far as getting the money, we have historically only charged what is appropriate for the use that somebody is gathering. So there is obviously penalties if you don't pay royalties right, or if you somehow damage the surface, you need to pay some restitution to correct that. But being punitive is not something that we have a process for and have not done in the past. And if they don't get a lease, we don't require them to pay. And that's just something we've not historically done. And I think that's my best answer for you.
Any follow-up? All right. Any other questions? Thank you, folks. Appreciate you coming over. Any others in the room? Mr. Obermueller?
Thank you, Mr. Chairman. Pete Obermueller, Petroleum Association of Wyoming. Mr. Chairman, we support the bill and ask that you move it. A couple of comments about the issue at hand based on the previous testimony. It is true that there's only been a small handful of instances where non-qualified bidders have bid on state land leases precisely for the purpose of, well, I won't speculate as to their purpose, but non-qualified bidders bidding. Mr. Chairman, a very notorious NGO, anti-public lands grazing NGO some years back, bid on a state lands grazing lease. Happened one time, and this body stepped in to make sure that that doesn't happen again. What we're asking for is the same protection that's been granted to our grazing operators on oil and gas leases as well. So that happened once, this has happened 4 times, et cetera. Now, the director has said, you know, that they have the authority to deal with it and all of that, and that it's true to an extent. But in this particular case that happened this past year, of course, what they don't have the authority to do, at least this is what they explained to the operator, is when this happens, they don't have the authority to reduce the bid price down to when the non-qualified operator bid in the first place. So what you heard from their testimony is they think that they're okay with that because it happens to be blind, that somehow that determines what the market bid is. When in fact, in our opinion, what that message sends to the activist NGO community, it's a Valentine to somebody like Mr. Bloomberg to invest $100 million to bid up oil and gas leases on state lands in order to make it more expensive for oil and gas operators to operate in Wyoming. That's what the bill tries to do. It is, as Senator Ellis pointed out, a deterrence mechanism. And it the original bill tries to deter it in 2 ways. One, you can't, if you're unqualified, it doesn't try to change the process at OSLI. They already have a definition for what's qualified. It's just internal to them. They look at it at every time. If Jones LLC comes in and bids on a lease and we don't know who that is, they have to make that determination today. And they don't necessarily always get that right, but they often do because they know what they're doing. And what the bill tried to do, it doesn't change that process. What the bill says, it tries to remove the incentive. 1, you know you won't get the lease if you are the winning bid. But also 2, you know that the oil and gas operator is not going to have their price artificially raised. That is an incentive to bid as a non-qualified bidder, to artificially make our expenses higher. And then 3, on the penalty, it's interesting to me that the argument that historically we haven't charged a penalty and we're uncomfortable with charging NGOs while we're trying to be very creative and do things that we've not historically done to try to make it more expensive for us. So the blind bidding pilot project, which we don't think is a good idea that they're trying, that's a creative way we've not done historically to try to get more money from oil and gas, but we're unwilling to do it for NGOs bidding illegitimately. That's concerning to me, Mr. Chairman. So we think the bill is necessary for the deterrence purposes. In the interest of moving the bill along, I think the OSLI amendment is okay. My primary interest is making sure that oil and gas operators can bid and not bid against illegitimate bidders. The penalty, particularly because it doesn't actually go to OSLI, I'm okay with letting that go, and I'm okay with their changes to match the process. We didn't intend to change the process for them at any point, but we could not just copy and paste what was done for grazing leases because it's so much harder to define what a legitimate oil and gas operator is than a grazing lands lease. I wish we could have just copy and paste. Doesn't work in oil and gas. We're willing to accept the ambiguity that comes with that, but there should be some deterrence for illegitimate bidders in this process. Thank you, Mr. Chairman.
Questions for Mr. Obermueller? Or not? I've got one really. If we were to say no to this bill, how desperate would we be? What kind of situation would we be in?
Mr. Chairman, I mean, it's impossible to answer that question because I don't know what people will do. But I think the efforts that have been made to bid on oil and gas leases from NGOs that are at best, concerned about oil and gas development, is a test balloon. Can they do it? Can they do it, and do they have the money to do it? Can they raise our costs? Can they make it harder to get an oil and gas lease? I think those were trial balloons. And if we do nothing, we're sending the message to them that, yep, you can do it, and it's totally great, and let's go find the resources to do that over and over and over again.
Thank you. Senator Rothfuss?
Thank you, Mr. Chairman. I have two questions. The first is with regard to the leasing, and this is something we've talked a lot about in recent years, is leasing the lands and then not producing those lands. And that's trouble for the state regardless of who does it. If an oil and gas operator leases lands and then doesn't produce those lands because it's, not part of their plan, but they've effectively got it locked up, that's just as expensive to the state as, leasing it by an NGO. And is there something that we could be looking at there as a remedy, which gets to, either start producing or lose your lease? And realistically, that could apply to anybody. So I'll start with that. What are your thoughts there?
Yeah, so Mr. Chairman, Senator Rothfuss, the process that you alluded to at the OGCC, of course, still applies. But it's a separate and distinct process from the leasing at OSLI. So you can still be under the rules that we work so hard on at OGCC with respect to permits and the 2-year timeline and all that stuff. But then you can lose an entire section of a built block, or at least have it be artificially inflated by the leasing process here. So, the OSLI is under the obligation at the end, as they do today, right now, at the end of looking at it and saying, is this a legitimate bidder? And they have to make that determination now. Again, do they always get it right? Maybe not. Does it take a long time to develop? You know that as well as I, but even on state land leases, you still have to have the OGCC process in order to do the drilling. So they're still under that permitting part of it. You could lose the rest of it, even if this one is not working out right. Does that make sense? Am I answering your question?
Somewhat, but
One quick follow-up, then I'm going to pace this because I want to get the banking bill in before we go back and ask Representative Larson to be patient maybe for another meeting, but we'll see what his facial reaction is here in a minute. In the meantime, ask one more question.
okay, I'll just stop there. Thanks.
All right, let's do this. Anybody else in the room would like to testify? Pete, do you have anything else to say?
No, Mr. Chairman, thank you for the opportunity.
Anybody else in the room? Okay, nobody's online. We have, we got different people on here. Ellis, you're on it. You want to move it? Move in second? Second? Good. Go page by page. We have a sponsor in the room. She'd like to speak. Page 1, page 2, page 3. Anybody interested in the amendment?
Mr. Chairman?
Okay.
Mr. Chairman, looking at the amendment, and this is my struggle, is I do think the amendment's probably more legally precise, but I'm not quite ready to move it yet. Senator Jones and I were talking about just some ideas, and so maybe she and I can visit with our petroleum industry and Office of State Lands and see if
Wanna lay
we
back?
can, and not lay it back, but bring a committee of the whole amendment.
Okay.
And if anyone else wants to be part of that conversation, certainly don't want to exclude anyone, but
Okay.
we're in the interest of time.
Right. Okay. We've gone through all 3 pages with the idea that we're going to amend on the floor. Want to take a vote count?
Senator Cooper.
Aye.
Senator Ellis.
Aye?
Senator Jones.
Aye.
Senator Rothfuss.
No.
Chairman Dockstader.
I'll be a no until I figure out that we need this that we actually need this, so. All right. Report the vote count.
Mr. Chairman, there are 3 aye and 2 no.
Okay, goes to the floor. Senator Ellis, you're carrying the weight on it, and you'll be responsible for the amendment. Okay, let's fit banking in. As my colleague tells me, we're at 1:20 for a return time. We need 5 minutes of space. Was anybody else on the room for that third bill? Representative Larson, you're here. Anybody else were you here for Representative Larson's bill? There's nobody online for that. Let's go ahead. Thank you, Representative Larson, for your understanding. Let's make sure the bankers get a little time because we bumped them back early in the process about 2 weeks ago. Who is presenting 145?
That's me.
Okay, go ahead.
Thanks, Mr. Chairman. This was the Blockchain Select Committee during the interim, but it was a Title 13 bill, so we couldn't sponsor it. And it wasn't quite done in time to run through, so we have it here as individually sponsored. But you'll recall, Mr. Chairman, that we passed Open Banking Act last legislative session. Our banking division during this interim spent quite a bit of time working through it and looking at what needed to be done, as well as working with what was going on at the federal level, and came up with a couple of tweaks. And so this is a bill representing those couple of tweaks. The first we see, the top of page 2, just providing a definition of customer, which is going to mean a natural person or an agent, trustee, or representative acting on behalf of the natural person, to provide clarity of what we're getting at for the customers that would be involved in the act. And then you see an addition at the bottom of page 2, that the participating bank shall limit the accessible customer data to that which is necessary for the customer to receive a product or service from the third-party financial service provider. So that's just additional consumer protection that ensures that a relationship, an open banking relationship, does not mean carte blanche to provide information, but it will be limited only to the information that needs to be transacted, and that's what it does.
Committee questions for Senator Rothfuss? There being none, we do have some banking authorities in the room. Well, I think he has some helpers back there too. Go ahead, sir.
Good afternoon, Mr. Chairman. Jeremiah Bishop, the Banking Commissioner for the Division of Banking. Like Senator Rothfuss said, this is something that we work with the Blockchain Committee during the interim period following the passage of the Open Banking Act last year. So if you remember last year, I testified that the CFPB at the federal level was working on their proposed rules that were very similar to in this area. They issued proposed rule in October of last year. They have not issued final rules. I don't know what their timeline is. That's an interesting agency. I'm not sure. There's a lot going on with them. But one of the things we did want to do was make sure that whatever we were doing was generally consistent with what's happening at the federal level. And so this customer definition matches up pretty much what is at the federal level. That was part of the Dodd-Frank Act, that definition. And in discussions last year, it was generally that open banking is for consumers. There's nothing prohibiting businesses from doing this. But this is kind of, I view this as that consumer protection bill so that consumers know what's going on with their information. It's generally accepted that if you're a business, you can still enter into one of these relationships. It's just you may not need the same type of or level of protections as an individual. So that's kind of why we wanted to insert this definition of customer. And then the second amendment here was something that we had discussed last year and during interim of just, okay, what's one of the more important items? And that is just to kind of get away from the current practice of how this works is the consumer works with this third party, goes through an aggregator third party, and they just get everything. They log into basically account information, and it's called scraping. They have access to all of your data. And so what this does is really limit what customer data can be provided to that third party. And the customer knows what's being shared. So we felt like that was a fairly important piece, and I think that's why we brought that forward. This doesn't change our rules very much. We're in the process of rulemaking at the moment. We'll implement some of this if we need to, but with that, I just answer any questions that you may have.
Sir, we're limiting the access to the data. Make it clear to me, what were we doing before? People could have access to.
Yeah, yep, Mr. Chairman. So there is nothing prohibiting the concept of open banking currently. Customers and banks can do this as long as they're in compliance with federal law. So the way this has worked in general over the past several years is, let's say you want to sign up for some third-party app for budget practice or something that they use a data aggregator, and there's really no good way for that aggregator to get your bank information. So as a customer, they might get your login information to your online bank portal, and that gives them access to everything. For basically anything you can see, they have access to. What this does is limit it so that if there's a specific, maybe you only want, I'll just come up with an example, just your savings account balances for a specific date. That's something that this could limit then. So that instead of getting all of your information from your bank, they could limit what information is being shared to just what the customer needs for a very specific product or service.
Committee questions? Banking Commissioner? All right, rather short. Anything else you'd add to it?
No, Mr. Chairman, thank you.
Thank you. You have some banking friends in the back. Would they like to speak? Yeah, pretty quiet group today. Do you have anybody online? May cut JT loose a little early, that's okay. All right. What's your desire, committee? Moved and second. Moved and second, you get those? Page 1. Page 2. Seems like this should have been done a lot earlier. Thank you. Let's go ahead and take the roll.
Senator Cooper.
Aye.
Senator Ellis.
Aye.
Senator Jones.
Aye.
Senator Rothfuss.
Aye.
Chairman Dockstader.
Aye.
Chairman, there are 5 aye.
Thank you. Representative Rothfuss, you got this on the floor? Okay, very good. Thanks, everybody. Here's what, let's talk for a minute. We'll take up Representative Larson's bill in our next meeting, which is Friday. And then we need to start getting some interim topics turned in. We haven't got anything assigned as of this, right, Tanner? We're after Representative Larson? There's nothing else?
Representative Larson is the only one that we have.
Okay, something can
remaining
come
after
along, but
today.
let's have you start to gather up your thoughts for interim topics at our next meeting, and we'll start to digest those and get those ready. Do you know our deadline for those?
To get them out of committee, Monday, I believe.
Okay, so Friday would be a good day to stay ahead of it.
So these two bills should be ready to hold them all.
Yes, correct.
Okay.
And we've got Rothfuss and Ellis. Yeah. And they're going to do a committee of the whole floor
Mr.
amendment.
Chairman, I might ask Senator Anderson or Boner too, if they have a preference on presenting.
Okay, fair enough.
I'll let you know.
Anything else for the good of the cause? That's it, thank you. You can shut us down.